you so much. You too. All right. 14A District Court is now in session. The Honorable Ortella is now presiding.
You may be seated. All right. Send that to Paul. We are now calling case number 25F12175. This is the people of the state of Michigan versus Sherrone Moore. Mr. Simon. Appearances.
Thank you, Your Honor. Good afternoon. Katie Rizmersky, First Assistant Prosecutor for the Special Victims Unit for the People.
And Your Honor, Joe Simon on behalf of Mr. Moore.
That's the charges, sir.
We waive formal reading of the complaint. Your Honor, stand mute to the charges.
Formal reading having been waived, plea of mute will be entered on your client's behalf. Simon, make your bond argument now or reserve?
Your Honor, I think the people want to make a presentation, and I'll go after that if that's okay.
All right, Mr. Wisniewski.
Your Honor, thank you very much. I appreciate that. Mr. Simon. And thank you for the opportunity to be heard. As the court is well aware, this is not a series of offenses in Michigan that allow you to deny bond. We're certainly not asking for that. This is a felony of home invasion third degree, misdemeanor stalking, and misdemeanor entry without permission. Your Honor, we are asking for a $25,000 cash or surety bond in light of the fact that we cannot ask for you to deny bond. I get that he is a man of means, and so this is a bit of a nominal monetary ask, but quite frankly, it would be an ask that I would make for any defendant charged with these offenses before you. So what strikes me as perhaps more important in this scenario are conditions that I would like to ask for, because of course, as you know, Your Honor, you're tasked with trying to make sure that he reappears, but also the safety of the public and this victim in particular. So, Judge, in addition to an ask for a $25,000 cash or surety, we are asking, should he post that, should you impose that, we are asking that you order that he undergo a mental health evaluation. We are asking that you order him to submit to a GPS tether and that there be a no-go to this victim's residence or place of employment. Ask that you order that there be no contact with her whatsoever in any means, any fashion, direct or indirect, that there be no stalking behavior of any kind, that he be ordered to surrender any and all weapons, further that he be ordered to surrender his passport. Judge, the reason, Your Honor, the reason we make those requests is in light of the factual scenario that gives rise to these charges. My best understanding from a thorough review of the police report and as much body-worn camera as I've had an opportunity to review is that I understand that our victim broke up. They had an intimate relationship for a number of years, defendant and victim, that our victim broke up with this defendant on Monday morning early, that there continued to be defendant making numerous phone calls and sending numerous texts from that time moving forward that she did not answer, did not respond to, and did not want. That eventually she presented herself to the University of Michigan, cooperated in some form of investigation there. As we all now know, defendant was at some point on Wednesday afternoon fired from his employment. He then, at some point soon thereafter, came to her apartment in the address that is alleged in the complaint, barged his way into that apartment, immediately then proceeded to a kitchen drawer, grabbed several butter knives and a pair of kitchen scissors, and began to threaten his own life. I'm going to kill myself. I'm going to make you watch. My blood is on your hands. You ruined my life. And a series of very, very threatening, intimidating, terrifying, quite frankly, statements and behaviors there in that apartment. It was only then, Your Honor, when the victim, she called her attorney and then at some point indicated she was going to call the police, and then he left. And so, Your Honor, while I understand that there isn't evidence to suggest that he directly threatened the victim with any of those implements that I've indicated, the totality of the behavior is highly threatening and highly intimidating. She was terrorized, Your Honor. And in light of the totality of all of those circumstances, we consider the defendant to be a risk to public safety, a risk to this victim, and it is for those reasons that we are asking for those specific conditions. I'm more than happy to answer any other questions that the court may have or give you further information, and I appreciate the opportunity. Thank you, Judge.
Mr. Simon is the bond.
Your Honor, let me start at the end where the people ended. In terms of risk to public safety, my client's 39 years old with zero prior criminal history, zero prior contact with the criminal justice system in any fashion. The threat to public safety argument by these charges, maybe that's the point, but there's no evidence to suggest that he's a threat to the public safety. The next thing is that the people referenced the court rule that I want to come back to, that you can't deny bond in a situation like this, and they referenced something else that I want to come back to, which is the fact that they reviewed thoroughly the police report, and they reviewed thoroughly the body cam. I've had none of that opportunity, and that's too early for that in the proceedings, so when people come here and make factual representations, although I trust Ms. Rizmirsky very much as an officer of the court, I have no ability to respond to those factual representations. So here's what I'm going to ask the court. The monetary bond component, the two considerations by court rule are my client will appear. Let me speak to that. He's got a home here. His family is here. He's got ties to our community. He's retained a local counsel here. Second thing is that my client is not otherwise a danger to the public or danger to the complainant. There are that is why monetary components are requested, but there are other measures to address them. For example, the request for a GPS tether, that was an expected request. My client will gladly comply with that request. The second thing is my client having no contact. Certainly, we have no objection to that order, and my client would be at his own peril if he were to violate that. His bond would be summarily revoked. In terms of surrendering the passport, Your Honor, there's no really indication that he is a flight risk. My client has those established ties that I talked about. But in addition to that, Your Honor, he would have an order from the court, like everyone else does. There would be no leaving the state, let alone the country, without permission of the court, and he would certainly abide by that. Your Honor, with respect to the request for a mental health evaluation, I will represent a few things that are my understanding, again, without being privileged to have reviewed discovery that. My understanding is that following his arrest, my client was taken to the St. Joseph Mercy Health System for an evaluation, a mental health evaluation. My understanding is following that evaluation, he was not turned over for a commitment, but instead turned back over to law enforcement for lodging. That's where he's been at the Washtenaw County Jail since. I can also tell the court that the Community Mental Health Department saw my client yesterday for an evaluation as well without any further recommendation. If you make that a condition of bond, I can tell the court that he get a mental health evaluation. He will absolutely comply and follow any aftercare recommendation. Lastly, Your Honor, with respect to the bond amount. I forgot to speak about weapons. He has no weapons, but he'll surrender. If you order that he surrender any weapons that he doesn't have, he'll be glad to comply with that condition. With respect to the bond amount, Your Honor, in a case like this, with charges like this, in a normal circumstance, we'd be requesting a personal recognizance bond and frankly expecting the court to order that. We all know this is not our ordinary circumstance. It's not an insignificant amount of money to anyone. And I ask that the court set the bond amount to the principles not of my client's bank account, but to the principles of the charges and to the principles of the courtroom. Therefore, I'm requesting that if the court orders a monetary component at all, that it be with a $25,000 10% privilege. And also, Your Honor, if my client is to order to a GPS tether, things have to happen pretty significantly to try to get that in place in time for what we hope to use in this day.
Mr. Moore, could you state your name, please?
Sherrone Moore.
Sir, you are not to use alcohol, marijuana, or any other controlled substance that is not prescribed to you. You are not to possess or purchase a firearm or any other dangerous weapon. You are not to engage in criminal conduct of any kind whatsoever. You may not leave the state of Michigan without permission of the court. Prior to your release, you will be placed on a GPS tether. You will not be released before that GPS tether is placed upon you. You must continue all mental health treatment as a condition of your bond. The named victim in this case will not be placed on the record. You may not have contact with that individual. That means no calling, no writing, no video chatting, no texting, no emailing, or any other form of contact the human mind can possibly fathom. No one in the world thinks that this person is going to reach out to you. Should they do so, and again, no one thinks that they're going to, you may not reply in any form or fashion. The named victim's address will not be placed on the record, but you may not go to that location for any reason whatsoever. Are we understood on the no contact and no go-to, sir?
Yes, Your Honor.
If you have any questions about that, you have a good attorney, simply ask them. Do you understand?
Yes, Your Honor.
Bond will be set in the amount of $25,000 cash surety, as requested by the prosecution's office. This court does not determine innocence or guilt. This court determines flight risk and community safety. The court finds with these conditions in place, it has been met. Mr. Simon, we are setting probable cause conference at this time for January 8th due to the holidays and scheduling. Is that a good court date for you?
Your Honor, my client will waive his right to have that next court appearance within 14 days. I've discussed that with him. I also try to coordinate calendars with Ms. Wismierski. In support of that, I think we're both available on January 22nd. The court would order that. And I'll add one more thing for the record in support of that. I understand that there is continuing investigation. So in addition to the discovery I don't yet have, there may be even more.
So it will be January 26th, 2020.
15, 22nd.
January 22nd, then. January 22nd, 2026, 9 a.m., 14A1 District Court, Courtroom C. That will be in person. Sir, do not violate these bond conditions. Follow all orders of the court. Stay in contact with your lawyer. That concludes this hearing.
Thank you, Your Honor.
Thank you very much.
All right, we're off record. We're going to give 10 minutes for everyone. We're going to take a recess.
All right, please.